Namo Harihandanam, Namo Siddhanam, Namo Ayariyanam, Namo Vajaya, Namo Isavasamunam, Eso Panchanamukaro, Sarva Baba Panasano, Mangalanam Chesadesim, Padamam Havai Mangalam, Padamam Havai Mangalam. நீராரும் கடலொடுத்த நிலமடந்த கெழிலொழுகும் சீராரும் வதனமெட திகழ்வரத கண்டமிதில் தெக்கனமும் அதிசிறந்த திராவிடனல் திறனாடும் தக்க சிறு பிறை நுதலும் தரித்தனரும் திலகமுமே அத்திலக வாசனை போல் அனைத்துலகும் இன்பமுற எத்திசையும் புகழ் மணக்க இருந்த பெரும் தமிழனங்கே தமிழனங்கே உன் சீரிழமை திரம்பியந்து செயல் மறந்து வாழ்த்துதுமே வாழ்த்துதுமே வாழ்த்துதுமே.
Today we have with us Ms. Asta Sharma, Assistant Senior Patent Attorney of LS Davar & Co. She is a registered patent agent with the Indian Patent Office and an experienced patent attorney. She comes from a background of chemical and pharmaceutical domain, along with a degree in law. She assists clients with the end-to-end patent services and represent both the Indian and multinational companies, including startups, universities, natural persons before the Indian Patent Office. Her work includes patent drafting, searching, attending hearings, interviewing inventors, and providing legal analysis. She has worked on several patent applications, including Indian patent applications and applications of other jurisdictions such as US, EP, China, Japan, Korea, PCT, Australia, Canada, and many more. She provides her opinion on the inventions related to the area of pharmaceuticals, nanotechnology, material chemistry, pharmaceutical composition, medical devices, inkjet printing, laminates, and composition or the likes. She also looks into pre-grant, post-grant opposition proceedings, appeals and revocation proceedings, and assist and represent client before the authority in various such matters. She is a regular speaker in various national forums, universities, Chamber of Commerce, sharing views on Indian IP perspectives and key developments in the IP scenario. She is an avid reader and writer and always curious to learn new things. She has also published various articles, newsletters, and try to keep her audience updated by sharing updates and developments in IP domain. Thank you so much, ma'am, for being here and looking forward for your presentation on career opportunities in IPR. Thank you, ma'am.
Thank you, Deepa, for that wonderful introduction. I am very grateful and happy to be part of the series. And I also thank you for inviting me as a speaker to speak on the topic patent agents and their careers. And I would also like to make this session more insightful, informative, and interactive so that everyone can make best out of this 1.5 hours of presentation. So shall I start with my presentation?
Yes, ma'am.
Okay. So my screen is visible?
Yes, ma'am, it is.
Okay. So good morning, everyone. I am Asta Sharma. As Ms. Deepa has already mentioned, I am working as an assistant senior patent attorney with LS Davar. Ellis Dower is the oldest law firm of India in IPR domain, and it established in 1932, and we are celebrating its 90 glorious years, which provides its services in patent, trademark, and other related IPR fields. And it also provides its expertise and services in all other IPR domains such as patent, trademark, copyright, designs, geographical indications, and many more. So this was about my firm. I shall start with my presentation now. So the topic for today is patents, patent agents, and their careers. Since many of us are new into this field, and a lot of people are not much aware of patents and what exactly the patent agents do. So this session is dedicated towards the brief introduction of patents. Then I shall be talking about who is patent agent, then who can become a patent agent, the role of a patent agent. Further, the Indian Patent Act has dedicated Chapter 21 towards the role, responsibilities of a patent agent, eligibility criteria. I shall be discussing that as well. Then the procedure for becoming a patent agent. What is the difference between a patent agent and an attorney? At last but not the least, we shall also be discussing the career options for patent agents. So what is patent? I hope everybody is clear what is patent, but I will be telling you in a very layman language and simple language what actually the patent is. Patent is an exclusive right which is given to the patent owner. It provides, what does I mean by exclusive right? Exclusive right means that it can help the patent owner to stop others from selling, using, importing, or manufacturing the patented product. This right is given for 20 years from the date of filing. In return, if you'll get a right on your patented product, you need to disclose each and every technical details about your invention, and that would be published in a public domain. Once the 20 years period is over, so this patent will be off patent, and the people will be free to sell, use, import, or manufacture your patented product, because the monopoly would be given only for 20 years. After that, anybody can use it, sell it, import it, or manufacture it. So why do we need patents? So like if you will speak to some people who are new to this field or the startups, they know about patent, but they don't know what is exactly the need of the patent. Why do the patents form a crucial part of their startups or for their product? So these are the points which you can also list down. I have listed down it for your reference. First of all, the patent will protect your invention. Firms and the inventors can obviously generate maximum profits from the patented product, because once you have a protection on your product, you will be the one who will be deciding who is going to sell it, import it, use it, so you can charge the royalty out of your patented product. Protection of your invention is one of the most important criteria to get a patent, because if you are putting a lot of research efforts and funding by in making your product, you obviously need a right to protect your invention so that nobody else can copy your invention. So this is where the role of patent comes. Then patent also helps in driving economic growth. It also helps in reducing the competitiveness, because if you have a protection, obviously nobody is going to dare to copy your product if you are already protected, because you can file an infringement suit or take a legal action against that person who is copying your product. Invention is also enriching in the public knowledge. It also enables and inspires others to develop further or research further. So this is the need for the patents. Now, one of the most important questions, because always the one who is going for patent, they want to know what is the benefit of investing so much in patent. What will they get out of protecting their invention? First of all, they'll be reducing the competitors. They'll be the one who will be monopolizing the market. They'll be the one who will be the bigger player in the market. So it helps in revenue generation, how they can generate revenue. by licensing, by sharing their technology or transferring their technology, by a way of assignment, by merging and acquisition of the other firms, also by IP auction. It also helps in confidence for venture capitalists or other inventors who are interested in funding your product or your startup or your company. IP portfolio also adds in increasing the valuation of your company. As bigger the portfolio of your company is, IP portfolio, the bigger the valuation of your company. IP portfolio can be sold out separately, therefore results in revenue generation. It also helps in establishing a goodwill because you have a monopoly, your name will be in the market. And it also helps in negotiating and licensing from the position of a strength because you have a huge, or I would say a strong IP portfolio. So these were the benefits of the patents. Does anyone have any questions regarding the basics of the patents? Okay, then I shall move to the next slide. So now the topic of today, who is patent agent? So patent agent is defined under Section 2N of the Patent Act. It says any person who is registered in the Patent Act as a patent agent is considered as a patent agent. So what does it mean? So it means any person who is authorized under the law to practice before the controller of the patent is a patent agent. One who is registered and authorized by the law to prosecute, to file patent application at the patent office is a patent agent. Now, who can become a patent agent? Not everyone can become a patent agent, but those people who clears these 5 eligibility criteria can become a patent agent. So first of all, these provisions or the qualifications are laid down in Section 126 of the Patent Act, where it says a patent agent can be the one who is a citizen of India. He should not be less than 21 years of age, should have a bachelor's degree in science, engineering, or technology from an authorized university, should have passed the patent agent examination, or he can be the examiner or the controller of the patent office for not less than 10 years. If the person is an examiner or a controller at the patent office, he can directly become a patent agent and can file or prosecute the patent application. He should pay the prescribed fee for registering himself as a patent agent at the patent office to become a patent agent. So these are the criteria which is required to become a patent agent. And one must note that before 2005, a degree in law was also required to qualify as a patent agent. But now that requirement has been waived out. Only a degree in science, engineering, and technology would do to become a patent agent. Now, what exactly patent agents do? So the role of patent agent I have listed out few responsibilities of a patent agent. First of all, patent agent should interview the inventors to understand their invention. So once the inventor is done with their invention, it's the duty or the responsibility of a patent agent to interview that inventor to know exactly what he has invented, to find out what exactly the novel and inventive feature in that invention, and to understand from where that invention is coming out and what problem it is solving. So that's how the interview of the inventors are taken place by the patent agent. Then, based on that input, a patent agent is required to draft a patent application, which is a techno-legal document where you need to provide every possibility, every technical features which is present in the invention in your patent application. Then you can file that patent application in your name. Only a registered patent agent can file a patent application. Then the patent agent can provide its legal opinions on the technical matters under his name. Until and unless you are not a patent agent, you cannot provide a legal opinion to your clients or your inventors. You need to have the registration as a patent agent to provide an opinion. Then you can represent your clients on the technical matters, and you can also provide your opinion to the controllers on behalf of your applicants or inventors if you are a registered patent agent. You could be a mediator between applicant patent office, where you can convey the features of the applicant's invention to the patent office by being an authorized person in between. Patent agent can also aid inventors with finishing and submitting their patent application. Patent agent can also do prior art searching. So what does prior art searching means? So if there is an invention done by an inventor, you would be the one who will be looking for the similar invention that already exists in the public domain. And accordingly, you let your inventor know that this is something closer to your invention. Please see to this document before filing a patent application, because this can become a prior art in the examination report. So we should address it before filing a patent application. So this is also one of the activity that has to be performed by the patent agent. Then you can advise your client about the chances of the patentability of your invention, and what is the likelihood of getting your patent granted. Further, you can answer the controller only if you are a patent agent. You cannot attend a hearing or you cannot speak to the controller until and unless you are a registered patent agent. You have to write legally enforceable claims that helps in proving the ownership of the invention. Further, the revision of the rejected patent application has to be done by the patent agent only. Also, this is one of the most important criteria. Patent Act or the patent laws keep on revising every now and then. A patent agent should be able to keep up with those amendments and revision, because that's very important to keep your clients and the inventors updated, because that helps in prosecuting your patent application. You should be the one who should keep reading with the new amendments and revision and should imply in your practice. Now, what are the rights of the patent agents? Section 127 and 128 of the Patent Act defines the rights of the patent agents. First of all, it can practice before the court. He can prepare all the documents, transact all the businesses, and discharge such functions such as prescribed to the proceedings of the patent application. Maybe it's a telephonic interview with the controller, or it is a hearing, or you are submitting any formal documents. All those can be done by the patent agent only. All the application and communication to the controller has to be signed by the patent agent on behalf of their client or the applicant. All the documents which are submitted at the patent office should be authorized or verified or signed by the patent agent only. So these were the rights of the patent agents. Any questions so far? Okay, then I shall move to the next slide. Now, there are some restrictions as well on patent agents. It's not that every patent agent can practice until unless it is lawfully registered and authorized under the law. Section 129 discusses those restrictions on the patent agent. So no person alone or with any partner can call himself or herself a patent agent until and unless that patent agent has actually cleared the exam and has been registered under the Patent Act lawfully. So no one can put his title as a patent agent until and unless that paper has been cleared, or that the person has paid the prescribed fee at the patent office to become a patent agent. Similarly, no company or any firm should call themselves as a patent agent company until and unless all the employees are registered as a patent agent in that company. So these are the restrictions which is on the practice of the patent agent. Also, this section defines what the practice means. So nobody who is a patent agent can obtain a patent in India in their name. So if you are not a patent agent, just mentioning the title cannot help you in obtaining the patents, or preparing specification or other documents for the purpose of this act cannot be done by a person who is not a patent agent, or giving advices other than of a scientific or technical nature or onto the validity of the patents without being a patent agent is prohibited under this section. So until and unless you are not a patent agent, you will not be able to obtain any patent or prepare any document for your client or give any advice on the validity of the patents or their infringement. Now, removal and restoration. So obviously, when a patent agent is registered, there is a power vested in the controller to remove the name of the patent agent or to restore it. Section 130 of the Patent Acts talks about those criterias where the controller can restore or remove the patent agent name from the Patent Act. So if the controller thinks that first of all, he will give the reasonable opportunity to the patent agent for being heard and to provide his reasons why that person is the registered patent agent, what all are the documents that prove that he qualifies all the eligibility criteria of being a patent agent. If he thinks he is not satisfied, he may remove the name of that person. Further, it might be possible because there are a lot of people with similar name and the surname. So it happens that because of some suppression of material facts or misrepresentation, someone else's name has been registered by error. So that can also be removed by the controller if he finds. Then if any person who is convicted of an offense or has been imprisoned or has been going through any sentence or has misconducted in his professional capacity and controller thinks that he is unfit to be a registered patent agent, he can remove his name as soon as he finds someone misbehaving with him or with his clients, or any such misconduct would not be tolerated, and the controller may remove the name of the patent agent. The other criteria is if someone else feels or provides any sufficient cause to show that the person who is a registered patent agent is not the actual person, the controller, after giving an opportunity, may decide on it whether to remove or restore the name. Further, the controller has also the power to restore the name of the patent agents. How one can restore it? So, as you must be aware that once you are a patent agent, you have to renew your registration every year. If by error you are not able to restore it, or if you have missed the deadline, you may pay the fees along with the reasons why you have not able to pay the fees on time. The controller, after seeing the sufficient cause, may restore your name, and also may not restore the name if he thinks that the cause provided to him is not sufficient to show that the payment was not made. So these are the powers which are vested under the controller to restore or remove the name of the registered patent agent from the Patent Act. Further, there are a few more power of controllers that is discussed in section 131 of the Patent Act. So, as I've already told, that controllers has the power to restrain himself in dealing with certain patent agents. Controller may refrain any registered patent agent or remove his name if he thinks that the person who is a patent agent is convicted of an offense or is prohibited by the law, or any person who is in the opinion of the controller is employed in the business of patenting or filing a patent application, but actually he's not a lawfully registered patent agent and he's just misusing the title of the patent agent. Similarly, any firm or company whose manager or the director is not a patent agent, the controller, just because he's the partner or the manager of the firm, can refrain them from attending the hearing or dealing with the patent application because that person is not a registered patent agent. Similarly, any person who doesn't belong to India or does not have any place of business in India cannot deal with the filing of the patent application. So the controller, if finds so, can refrain that person from attending the hearing or for using the title patent agent. So who else can deal with the patent? So along with the patent agents, the applicant also who has invented, applicant on behalf of the inventor who has invented the application can draft the specification. In fact, an advocate who is not a patent agent can also take part in hearing on behalf of the applicant. So these two people other than the patent agents can also deal with the patenting of the application. Now, records for patent agents. So whosoever is registered, that record is maintained by the patent office. Earlier, they used to have a actual register, but now those registers has been shifted to the softwares where all the name, addresses, and the other relevant data which is required of the patent agent is stored, and their qualifications and everything related to the eligibility criteria are stored in that register of patent agents, which keeps on removing and restoring based on the renewal of the patent agent. So, is there any doubts or any questions regarding these slides which I have just mentioned and all those information which I have just now given?
No, ma'am. We can have the question and answer session at the end of the session, ma'am.
Okay, so shall I start? Shall I just keep on presenting and then at the end we can have a session?
Yes, ma'am. Yes, ma'am. And the queries will be posted in the chat box because we cannot, the participants cannot unmute themselves. So,
okay,
it
okay.
will be posted only in the chat box, ma'am.
Okay, okay, understood. So I'll be basically dedicating half an hour for the question answer session so that it could be an interactive session. So I will try to wind up my presentation by 12:30 and then we can have a half an hour question answer session. Would that be okay? I think
actually the career path in patent is entirely new for the academic people.
Right.
If the question answer session is long enough for half an hour, we can have it, ma'am.
Okay.
No issues. You can wind up by 12:30 as planned by you.
Okay, sure. Thank you. Now, patent agents, the procedure to become a patent agent. So as I have mentioned that the Patent Act has dedicated a complete chapter on the role of the patent agents, its responsibilities, and also the procedure to become a patent agent. So there is rules 109, 10, and 111, which talks about the process for registering a patent agent under the Act. First of all, once the date has been announced by the patent office, like in current scenario, it's in May. So the people who are interested and qualifies the eligibility criteria, which I have mentioned in my slides earlier, if that has been fulfilled by any candidate or any aspirant, he can submit an application to the patent office to appear for the examination. He can make such request by a letter or by filling an online form and by paying the prescribed fee of rupees 1600. So now I'll be talking about the examination. So what exactly the examination is about, and what is the format of the examination, and what is the purpose of keeping this examination to become a patent agent. So the patent agent examination is divided into two parts. First is a multiple choice question, and the second is a subjective question. Both the papers are of 100 marks. The multiple choice question paper will basically gives you the time to logically think what exactly the section which are required to be used. For example, if the patent office would like to know your and, basically would like to know your power of grasping the patent act. Patent Act 1917 is considered as a bible for all the patent agent. It should be thoroughly read, or basically should be thoroughly understood by a patent agent, because all the laws, all the criterias to file a patent application has been laid down in the Patent Act, and nothing could go beyond that Patent Act. Everything is mentioned in the Patent Act, what is required for filing a patent application and obtaining a grant. So this is a bible of the Patent Act. The purpose of keeping a multiple choice question is like how thorough are you with the Patent Act. So what they will do, they will give you one liner question saying which section says that the patent agent should have these qualifications. So you should know which section is it talking about. So to check your capability of following the Patent Act and to know how much you are thorough with the Patent Act, because it's very important to be thorough with your act. The purpose of keeping a multiple choice question is that only. So they'll be checking your grasping power with the Patent Act and how thorough and experienced are you with the Patent Act. Then there is a second paper of 100 marks, which is a subjective question. So subjective question, the purpose of keeping it behind is that when you are a patent agent, there are a lot of queries raised by the inventors, applicants of the national, like maybe a national citizen or maybe international citizen, who would like you to answer their queries based on the Indian patent laws. So the purpose of keeping that subjective paper is to see how well you can advise your client and how correct are you. So they'll be giving you situations, scenarios, and they'll ask your opinion that if you would be the patent agent, what are you going to do? What would you be advising the client? And then they'll judge you like how well you are prepared to be a patent agent. Second paper is divided into two parts, part A and part B, where part A have situational questions and part B is more particularly drafting, where there are two questions, one for the life science team and one for the mechanical aspirants or the engineering aspirants. So they'll be checking you how good are you in drafting. It's not necessary the people who are just passed out or who are freshers. It's not necessary that they should be perfect in drafting the patent application, but they should be clear with it. Like how well they know to draft an application and how well they know which points to be covered. So that is the main purpose. They won't see your exact technical inputs, but they will see how you put the invention into a drafting format and how you're going to draft the patent application. After you clear both the examination should be cleared separately. The total of those two papers should be 60%, but the passing criteria of individual paper is 50-50. But the combination or the sum of the two papers should be above 60% in order to clear your written exam. Once you clear your written exam, then there is an interview where you will be asked to come to the near patent office, where the controller will ask you questions related to your, maybe it could be a technical domain from which you belong, or it could be related to Patent Act, or they can give you a situation that they will ask you what will you going to advise to the client. I can give you my example. Since I'm from a chemical domain, I have been asked regarding some chemical questions. Also, I have been asked regarding some formal requirements and the technology transfer process, like how one can do the technology transfer. So these kind of questions are asked in the interview. Based on that, so you should clear your interview separately. So all these three exams has to be cleared separately in order to become a patent agent. So these are the particulars of the examination which I have just discussed. Now the registration process. Once you have cleared the examination, you need to make a request, or I mean, when I say the examination, it also means the interview as well. So once you have cleared the examination and the interview, you have to submit all your documents, which includes your transcripts, your document which shows that you are a citizen of India, like passport or Aadhaar card, anything like that. Also, any other certificate which is required under the eligibility criteria, that all you have to submit along with the form 22 with rupees 3200 to the patent office to register you as a patent agent. Once all your documents are verified and submitted at the patent office, the controller shall enter all your details in the patent agent, and you'll be then become a registered patent agent under that. Further, once you have been registered and the same and the certificate of registration has been provided to you, you can start working as an independent registered patent agent. You can start prosecuting and filing patent application before the court or represent your clients at the hearing once you become the registered patent office. There's one crucial point which I would like you to see, that if the documents that have been provided to the controller are false, or is there any suppression of the fact, then the patent agent will be liable for punishment or fine of rupees 1 lakh. And if the said act where you are misusing the title of the patent agent, then you will be fined with rupees 5 lakh with subsequent offenses. So you will also be penalized for misusing the name of the title or providing any false document at the patent office. Further, the patent agent has to renew its registration every year by paying rupees 800, but a consolidated renewal can also be done for up to 3 years, 5 years, or 10 years. A patent agent can submit the consolidated sum for the particular years for which he wants to register. Now, there have been a lot of, I would say, there have been a lot of there would be a lot of confusion or dilemma regarding the title patent agent and patent attorney. Some people used these terms interchangeably. Some people use patent agent or patent attorney being the same thing, but actually it's not. Patent agent, as I have told you in my previous slides, he's the person who clears the patent agent examination and register himself or herself as a patent agent under the act. He may or may not has a law degree. Patent agent does not necessarily has to have a law degree. He can prosecute patent application, he can draft a patent application, he can advise a patent application. So those things can be done by patent agent. But when it comes to a patent attorney must necessarily have a law degree with herself or himself. He or she can litigate the matter of the patent at the court also, because he's the registered bar council advocate. Patent agent cannot litigate the patent matter, but he can provide his technical inputs to a lawyer or the attorney. Attorney can also help in prosecuting an patent application, if he may or may not be a patent agent, because as I have mentioned in my previous slides, that other than a patent agent, an advocate and an applicant itself can help in preparing the patent application and obtaining the patent application. So in short, the primary focus of a patent agent is to prosecute the patent application, and the primarily focus of the patent attorney is to litigate the matter in the courts. So patent agent, as I mentioned, section 2 clause N defines the definition of patent agent. However, patent attorney is not defined under the Patent Act. And patent attorney does not necessarily, does not necessarily have a degree in science, technology, or engineering. However, he should be a qualified lawyer with a valid bar registration. So when one says that patent agent and attorney are the same thing, they are not, because attorney should be a lawyer or a advocate. Patent agent may not be a lawyer, but he has to be a registered patent agent under that, where he has cleared exams and has a degree in science, technology, or any engineering domain. This is maybe this is the last slide of my presentation, where I'll be discussing the career options in detail. What all a person being a patent agent can do. First of all, a patent agent, if you have cleared a patent agent, you can do a private practice, or you can be a freelancer where you can guide your inventors or the startups or the natural a natural person regarding the patent application and how to obtain a patent application. So you can do a private practice or freelancing. I have just noted a question in the chat, so I'll be taking all the questions after my presentation is done. Okay, so one can provide his private practice or his personal opinion to the client, as he's the registered patent agent. So he is easily able to guide the people under the law. So that is one of the career options. If you are not if you does not want to work with any firm or any manufacturers or any other companies, then you could do a private practice. The second option, which personally I feel is one of the best option, is working with a law firm. Law firm provides you, I would say, an immense exposure. They'll train you by providing various by giving you various life cases where you have to brainstorm, where you have to utilize all your technicalities, all your knowledge to guide inventors. Since I have always been associated with a law firm, maybe that could be a reason that I support working with a law firm, because in law firm you have independence of discussing your matter with the inventors. You can face various challenges, which is interesting. You get to meet a lot of new inventors with a lot of new inventions who wants your advice. There are a lot of different actions that you can play. You can do infringement analysis. You can provide your opinion on the infringement of a product, or you can do the patent drafting as usual, or prosecuting the application. You can also do um, cross-jurisdictional office actions, where you just need to provide your technical inputs. Because if application is of US, as you know, that Indian patent agent has to be an Indian citizen. Similarly, a person who has to file application in a patent should be US national. So you can at best provide the technical input to your US associates, and they'll be the one who will be filing in their name. So law firm, along with providing you the national application, they will also provide you hands-on training and experiences on the cross-jurisdictional case laws, patent applications as well. Now, the other option could be the in-house counsel for the manufacturers. So what happens, every innovator companies or every product or process company has their in-house IPR department, where they hire the patent agents or the advocates who deal with their R&D team, educate them with the IPR process, tell them what is actually required to file a patent, what all the prerequisites. As everybody's, I'm not sure, but when you need to file a patent application, the patent application should be novel, inventive, that is, it should be non-obvious in the already existing technology, and it should be industrially applicable. So these are the three prerequisites of the patent application to be patentable. So when you interview your inventors or when you are in-house counsel and you have to speak to your R&D team, the first thing which you need to ask and which you need to advise them to show what is new in your invention, and what is that feature that makes your invention non-obvious or out of the box from the existing technology, and how this invention is useful for the public, or how can it be industrially applicable. So that is the role of in-house counsels as well as the patent agents who are working individually or with the law firms. Even with the KPOs, there are a lot of KPOs, outsourcing firms, which hires Indian patent agents, which basically provide opinions to one multinational of US or Europe or any other country. So that is also another career option where you can go into the knowledge processing outsourcing firms, and you can use your advices or your technicalities or your knowledge by advising the companies of foreign jurisdictions. So that is also one of the career options that you can think of if you are a registered patent agent. Advising clients on patent rights. As you know that in India, enforcing patents or filing patent application has now paced up. Earlier, people were not well aware how to go about patents. What is it? What is the need? What is the benefit of patents? Now, every other person has become an entrepreneur where he's developing its own product, processes, or technology. So everyone wants to protect their invention because obviously everyone wants to make money out of it. It can be only done once your invention is protected so that nobody else can copy it. So you can advise clients on the patent rights, you can educate them about the patent rights and what all benefits they can get out of it, what all the need of the patents, and how to enforce it. So after your patent is granted, the other domain which is also underlying in this field is the licensing of the patent application. It's not necessary that every patent which is granted can be licensed by the inventor. I can give you an example. Suppose an university is working on a drug which shows surprising results, which has complete data. But that university has also applied for a patent application. He has also gotten grant for that application. But after getting a grant, since it's an asset, you need to use it. So how can you use it? You can use it by either licensing it to some other pharmaceutical manufacturers or some other companies which can use your drugs and sell it out to the market, or you can transfer your technology to these firms where you can ask for the money for transferring your technology, or you can basically sell your patent portfolio to other companies to just enforce it in the market. Because when you have invented something, you need to make money out of it. If you are not enforcing or licensing your patents, it won't do anything. It will be just a granted asset, but you cannot do anything with it if it is not enforced or launched into the market. So for that also a patent agent is required, because that is the person who can deal with the inventions and know the technicalities and know the credibility of the patent, like how strong the patent is, and he can also help you in negotiating along with the other lawyers or the counsels. Also, train aspirants of this field can also be a career option, as you have noticed that a lot of trainings and a lot of classes are going on for the patent agent examination. So people after becoming a patent agent also helps others aspirants to clear or crack that exam by teaching them, by educating them with the patent rights, or by providing them practice papers and all. So that is also one of the career options which can also be think about after becoming a patent agent, because if you are a patent agent, then only you can train other people to become a patent agent. Also, you can assist senior attorneys with patent matters. So there are a lot of, as you must be aware, that Intellectual Property Appellate Board, which is an authority after the Patent Office. So if any person who is aggrieved of the controller's decision, if any patent has been refused by the controller, he or she used to go to the IPAB for reviewing the decisions, for making sure that their patent application is revised or examined again so that their patent can be granted. Last year, that IPAB has been dissolved. Now the High Court has made a separate division, which is the Intellectual Property Division, to deal with such matters. Suppose infringement suits, people who are aggrieved with the controller's decision. So all the petitions, all the writs are now submitted in the Intellectual Property Divisions. So those divisions now specifically deal with the intellectual property matters. Draft rules for the division, like how it's going to process, how the matters is going to be heard, and if there is any technical member required to be present, and all those things, all those draft rules has been laid out by the High Court for the stakeholders, so that they have invited the comments in order to improvise the rules. But I believe by 3 or 4 months that division would be functional, and it will be specifically dealing with the intellectual property matters, not only patents but also trademarks, copyright, designs in of any other domains which comes under the types of intellectual property will be dealt by that division. So in courts, more specifically, the senior counsels and senior attorneys go, who might not be very well aware of the technical subject matter of that patent, of the technological domain. So that's how the patent agent come into rule. They can assist those senior counsels, or I would say any other counsel who is representing the matter in the court, by becoming their technical member, or by helping them or guiding them with their technology domain. So that could also be considered as one of the career options. So this was all from my side. Thank you very much for being a part of this presentation. I am open for questions now. So I guess Ms. Deepa can unmute people so that they can ask questions, if that is okay.
Asta, there are a few questions which is posted in the chat box. You can answer those queries.
Okay, I shall just look into it now. Okay, so first question is of Mr. Chinmay Panchal, right? Okay, so thank you for appreciating this session. Role of patent agent in cross-jurisdictional patent prosecution. So as I have mentioned, when you are a patent agent, you should be of that nationality, being it a US patent agent, EP patent agent, or Indian patent agent. Now, suppose we are an Indian patent agent, can we do cross-jurisdictional patent prosecution? Yes, we can do. We hire our US counterparts, EP counterparts, or any other jurisdiction where the inventors want to get their patent filed. So we do all the background thing. We prepare the response to the office action. We give our technical inputs. We give our formal requirements. We give all the answers to the objections that has been raised by the examiners of the different jurisdiction. But that should be filed in the name of the agent, which is the national of US. So what we do, we just prepare the response. We send it to our US attorneys or EP attorneys. They file it in their name. So that's the role of patent agent in cross jurisdiction, because suppose Indian applicant is filing in a US application. So you will be the one who will be mediating between the US attorney and the applicant. The way you used to do it for controller and the applicant in India, the same way you do it for US attorney and the applicant during a cross jurisdictional jurisdictional prosecution. So I hope, Chinmay, I was clear. If you really want to know something else also with this regard, please let me know. Salary or pay package that can be expected by a fresher patent agent. So Chinmay, basically packages is variable in nature for different people based on their technical domain, based on the qualifications they are carrying. People with master's degrees have different package. People with bachelor's degree have different package. PhDs will have different package. People with a law degree have different package. But I cannot give you the numbers, but I can say the package for patent agents is far more better than freshers in other domains, be it IT or any other domain. Packages for freshers in patenting field is higher than that. Okay, can you, and then I hope Chinmay, I have answered your queries. Now, Omkar has raised a question saying, can you clear the point attorney and agent once again? Sure. So agent, as I have mentioned, patent agent should necessarily have a degree in science, engineering, technology, because patent is an invention which is um related to something which is in science domain, engineering domain, technological domain. So the knowledge of that domain is very important to being a patent agent, because you have to draft that patent application with your knowledge, and you have to be very clear with your basics of your domain. So patent agent has to be necessarily really in the field of the science, engineering, or any other technology in order to be a patent agent and prosecute it. Because once the office action or examination reports come, it requires your technical inputs to address the objections of the controller. When you attend hearing, controllers are also of your technology, so they will ask you question regarding to your technology. You must be aware of those basics and of those technical terms. Only if you are a person with that degree or with that knowledge of technology, then only you can become a patent agent. However, for attorney, so attorney is a lawyer basically. It's not necessarily that he or she has to be with a science degree. He can be a person of a commerce degree, but that attorney who has a valid law degree and registered under the bar council can represent an applicant at the court. So in court only those person can go, who can represent the client, who is a lawyer and registered under the bar council. But patent agent is not a lawyer, he is a person with technical knowledge. So attorney is a lawyer, patent agent is a technical person. So when you have to litigate a matter, when you have to do all the legal, you have to put all your legal knowledge, then a lawyer is required. When you have to prosecute the patent application, you are required to have the knowledge of your technology, because that is required to um, basically address the objection that has been raised by the controller. So I hope, Omkar, I was clear with that. Now, Chinmay has asked for the invention to be patentable. One of the requirements is novelty against the world. However, the rights provided are territorial. Why the novelty is also not checked within the territory, say Indian jurisdiction only? And that's a good question. But see, I would say, Chinmay, and patents are a territorial right. But would you think it would be fair for the people who has invented who has invented a product by putting a lot of funds, research efforts, and has patented that application in US, a person in India who has done nothing, just copied that US application and has filed a patent in India? Would that be fair for the US citizen to have just to easily get the Indian national to copy their invention and file a patent for it? No, right? The Indian controllers are very strict to actually patent is not I would say patent is not a gift given by the patent office. It's a reward given to the inventors for their efforts, for their research, for putting out their brain. That is a reward. So to earn that reward, you need to be out of the box. So if such kind of a product is already available in the other jurisdiction, not in India, then what's the efforts you have put in? So that is the criteria set by the patent law or the patent act, that you need to be innovative. You need, in order to be an inventor, you should be an inventor by doing something new. Copying some other product and filing the patent application would not make you eligible to be an inventor, first of all, because as per the definition of the inventor is some true and first inventor is someone who has invented that product that has not been existed in the technological domain or the public domain. So that's why the novelty is checked all over the world to see whether actually the inventor has put in efforts and whether he is worthy of giving the product, because monopolizing the market because of your product which you have copied is not at all fair for the public or for the Indian market. So if you have actually done something, you are liable to get a patent, but if you have not, then obviously you will not get a patent. I hope I'm clear, Chinmay, for that. Then if I wish to have a patent grant related to product as well process of my invention, the application for patent grant shall include for product as well as the process related to the single invention, or both have to file separately separately. Okay. So Indian Patent Office has laid down a section 10.5 which talks about unity of invention. So if you have invented a product, a process of preparing that product is linked by a single inventive concept, so that can be filed in one application. But if you are preparing two products which are different from each other, or if you are preparing one product and you are also inventing one process to prepare a product B, which is not related to product A, then you are supposed to file two different patent applications, because those two patent applications are not interrelated. So as per section 7.1 of the Patent Act, only for one invention a patent can be granted. So if there are more than one invention in your patent, then you are required to file two different applications. But a product and a process of preparing that product will be can be present in one patent application because they are interlinked. I hope, Chinmay, I'm clear. Yeah, I got your message. Thank you for your questions. Do I need to, there's a question, can you please share your email ID? Is it for me? Do I need to share the email ID?
Ma'am, that is left to you, because there are a few participants who always ask for the contact details of the resource person. So
Okay.
this is left to you. If you want to mail them, if you want to send your mail details to them, you can, ma'am.
Okay, I'm no problem. Like, I can help them if they want any query related to patent or any information they need from me regarding the subject matter.
Yes,
I
ma'am.
would be happy to help them. So I'll just
Yeah.
write it down there.
Sure, please.
Thank you, Omkar, for appreciating the session. I hope you all liked my session and find it informative and useful for your patent agent examination or for patent related queries. You can contact me. I have given my email ID, and I'm open for more questions. If there are any questions, please let me know.
Is there any other questions? The feedback form is posted in the chat box. The people who have filled the feedback form will receive the e-certificates. Deepika, I request you to formally propose the vote of thanks.
Yes, ma'am. Good afternoon, everyone. It is an honor to propose the vote of thanks for today's session. I would like to thank the Almighty for making today's session a success. I extend my gratitude to our speaker, Ms. Hashta Sharma, for taking the time to be a part of the FDP on research and IPR and for sharing the wonderful session today. I thank all the participants who have taken the time out to attend today's session. A big thank you to our secretary and our associate secretary for their constant guidance and support. My special thanks to our principal, Dr. S. Padmavati, and Vice Principal, Dr. S. Rukmani, for giving us the encouragement we always need. Last but not the least, I would like to thank Dr. S.T. Deepa, our technical team, and our internal training team for all their support and coordination. Once again, I thank you all.
Thank you, Deepika. And I also thank everyone who was present in the session and giving your time to me to help you knowing some career options regarding patent agents and how to become one. Hopefully to see you in some other session. Thank you so much.
Thank you so much, ma'am. Thank you so much for taking your time during the weekend. Thank you so much, ma'am.